Thank you. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5240. Kevin Owen McCarthy, the Honorable, in his official capacity as House Minority Leader and member of the United States House of Representatives for the California 23rd Congressional District et al., appellants, versus Nancy Pelosi, the Honorable, in her official capacity as Speaker of the House of Representatives and member of the United States House of Representatives for the California 12th Congressional District et al. Mr. Cooper for the appellants, Mr. Letter for the appellees.
Good morning, counsel.
Good morning, Your Honor.
Good to see you. Mr. Cooper, please begin when you're ready.
Thank you very much, Mr. Chief Judge, and may it please the court, Charles Cooper for the appellants before you, who are the plaintiffs in the court below. The central issue in this case is a speech or debate clause issue, and that question is whether the defendant House officers in this case are immune from this suit in which we are challenging their acts in executing and carrying out the proxy voting process established by House Resolution 965. And we submit they are not immune from this suit. And the reason relates to this court's clearly drawn temporal distinction following Supreme Court precedent between legislative acts, things integral to the legislative process, which are immune on the one hand, and acts taken in execution or carrying out such legislative acts, which are not immune. And this court's case in Walker versus Jones articulated this temporal distinction. It's a temporal distinction very, very clearly. In that case, then Judge Ruth Bader Ginsburg wrote for the court in Walker, that the Supreme Court has drawn a key distinction, she said, between acts that are legislative in nature and acts that, in her words, execute a legislative order or carry out a legislative direction. And Judge Ginsburg, Judge Ginsburg, then explained the temporal quality of that distinction. This is what she said, and it's worth quoting her words in full, Your Honors. The Supreme Court has instructed that execution of a legislative decision is not cloaked with speech or debate immunity. For execution or carrying out legislative directions postdates what the clause protects, the process leading up to and issuance of the legislative direction. And so in that case, the legislative subcommittee deliberations and ultimate decision to fire the House Food Service manager, those were immune from challenge.
Can I ask a question about this temporal dimension as you describe it?
Yes.
I understand the point, I think, where you have legislation and then it's executed, and the execution itself doesn't have to do with legislating. What seems potentially different about this case is that you have a House rule and then it's executed, but the execution itself has to do with legislating because the House rule is about how to vote. And so it seems different from the principle that you're identifying in Walker, because here, the acts that are coming about that you're deeming executive acts are themselves intimately bound up in the process of legislating. And in fact, in Walker itself, for example, the opinion says activities integral to the legislative process may not be examined, but peripheral activities not closely connected to the business of legislating do not enjoy speech or debate shelter. And when I look at that phrase, I think that what we're talking about here seems integral to the legislative process, and it is closely connected to the business of legislating. Even though I take your temporal point, it's an execution of a House rule, but the execution itself has to do with the business of legislating.
Well, Your Honor, I would suggest to you that that is not a dispositive or meaningful distinction in the court's distinction, again, between those things that lead up to a legislative directive, the things that are bound up with deliberations and what led to House Resolution 965, any more than, for example, in the Powell case, the the activities that the congressional officers, in that case, the sergeant at arms, the doorkeeper, were ordered by a House resolution, Your Honor, to undertake, including barring from voting a member on the House floor. So there again, that act itself related directly to voting, yes, for one member, but it still was bound up with the question of voting. The other thing I would say, Your Honor, on that point, is that it is certainly true that voting, as a general matter, is integral, of course, to the legislative process. Many cases have recognized that, and no one could deny it. But proxy voting is a different thing altogether. That can't be considered as integral to the legislative process, Your Honor, because it's never happened before. It's hardly plausible that something that's unprecedented, has never happened before, is somehow integral to legislation and legislative process. Your Honor, the Congress hasn't been kind of stumbling through its 231-year history, unable to use and never attempting to use some type of feature or tool that is integral to the deliberative process. And so to return to my central point, which this concerns this temporal distinction, I want to emphasize that nothing in this case challenges any deliberation, any hearing, any subpoena, or any vote that led up to the enactment of 965. To the contrary, we seek only relief against congressional officers for their acts after passage of House Resolution 965 in executing and carrying it out. Now, the court below placed a controlling emphasis on the Consumers Union case. And I want to address that case because far from controlling in this circumstance, we respectfully submit, it is entirely distinguishable and distinguishable at three different levels. First, it is not a speech or debate clause case. It's a hybrid case in which this court held that the political question doctrine and the speech or debate clause operate together inextricably to require dismissal of the plaintiff's claim in that case, and claim that it had been that the plaintiff there, Consumers Union, had been unconstitutionally denied access to the press gallery in the House.
On that point, Mr. Cooper, that we'll go back to the Walker opinion that you started off with.
Yes.
Walker describes, you're right, of course, that the opinion of Consumers Union invokes both modes of analysis, but Walker describes Consumers Union in terms of a speech or debate conclusion.
Yes.
Right. So it's not, I don't know that we in Walker looked back at Consumers Union and says it has nothing to do, we can't draw lessons about speech or debate because it was bound up with political question notions as well, because the way Walker describes Consumers Union is that it had to do with seating the press in the House and Senate galleries, and that was integral to legislative machinery, and thus were immune from judicial review by virtue of the speech or debate clause.
Fair point, Your Honor. I would point out that in this court's decision in Barker, the court recognized the fact that the decision itself was bound up with political question and speech or debate. But Your Honor, even if the court, despite the admonition by the Consumers Union court itself, that it thought it would be improper to view either political question or a speech or debate side of its analysis in isolation. If the court does view speech and debate in that case as in isolation, it's still readily distinguishable because that case, Your Honor, is not one that falls neatly in this temporal distinction that I previously outlined and that we've discussed, Mr. Chief Judge. It doesn't, because in that case, and I should say before proceeding that our case does fall neatly within that distinction. And for that reason and that reason alone, we prevail under the speech or debate clause. But Your Honor, the reason that it doesn't fall neatly within that temporal distinction is the third basis for distinguishing that case. And the court emphasized in Consumers Union that the process by the Periodicals Association in that case of policing press access to the House chamber took place on an ongoing day in, day out basis, as the court put it, in the regular course of the legislative process. And so in that regard, what that association was doing on a day in, day out basis was much the same as what the House chaplain does essentially every day as it opens legislative sessions, which was at issue before this court in the Barker case. And so the question simply boiled down to, in both the Barker case with the legislative chaplain and in Consumers Union with respect to the association, whether or not those ongoing day in, day out activities were an integral part of the deliberative and communicative processes of the House. The court in Barker said, no, the legislative chaplain activity is not. The court in Consumers Union said, yes, it is.
So is that how you deal with the temporal part of Consumers Union? Because Consumers Union in some ways could be described as parallel to this one, and that also involved rules. And then the particular case involved a particular implementation of the rules after the rule was adopted. And that's the way you've described this case too. Now, one thing you could say and potentially is, yeah, but that happened fairly regularly. So every time you were implementing the rule, you were also kind of carrying on this daily interaction with the rule. Whereas here, you could argue that it's more sporadic. But then when a vote is taken that involves, if more than one vote is taken that involves proxy votes, then you're necessarily in this kind of in-between period where you're anticipating another proxy vote coming along later also.
Your Honor, you're making a very, very fair point. And I think that the Walker case does indeed understand what was happening in Consumers Union as not falling in to this temporal distinction that the court emphasized in that case. Because if it had viewed it that way, it would have had a very hard time not understanding what the Periodicals Association was doing as not executing congressional orders. So it did view, as I think the court has just suggested, and the ongoing regular day in, day out process, much as I say, analogous to the chaplain, the House chaplain in the Barker case, as outside of this execution versus legislative act dichotomy.
Now, Walker did say in reference to Consumers Union that Consumers Union immediately concerned House consideration of proposed legislation. And so it's looking at the effect of the press gallery rule in the context of the legislation that's being considered while the folks are being seated, right? And so in a way, it's talking, the parallel you would say is, well, by parity of reasoning here, the House rule has to do with the tabulation of votes in connection with a proposed legislation that's yet to come to pass.
Well, that's right, Your Honor. But if I'm completely following the court's point, but Your Honor, I would direct the court's attention to how then Judge Ginsburg framed Consumers Union and why it was integrally involved in the political, in the legislative process. The court said that It involved regulation of the very atmosphere in which lawmaking deliberations occur. Your Honor, that point in and of itself sprang from the reality that the delegated responsibility for the Periodical Association was to protect legislators themselves in the chamber from the harassment of news reporters, actually those masquerading as news reporters who are actually lobbying and otherwise importuning the legislatures. So the very atmosphere of the legislative process was at stake in that case. That is integral. The court, Your Honor, for example, again in Barker, the legislative prayer opening every session, Your Honor, is not, and so therefore is not protected by speech or debate. Here, again, I would reiterate that the actions taken by the congressional officers in this case can't be viewed, we would submit respectfully, as integral to the legislative process, because proxy voting itself can't be viewed that way. It is, as I mentioned earlier, it's unprecedented. And Your Honor, something that has never happened in 231 years, it seems to us very difficult to say, is integral to a deliberative process and a legislative process that has worked well for those.
Right. I mean, that does get in some measure to the merits of whether proxy voting is or isn't something that falls within the compass of something that the House is permitted to allow. And can I ask you, shift gears for just 1 second and ask you one question about standing? Although I don't want to take my colleagues away from speech or debate if they have some questions on that. But I have a standing question for you. And I know that the district court didn't ultimately rule on standing, but the issue was before, and both sides have briefed it amply in our court.
Yes, sir.
So is your theory of standing, does it mean that any time it's easier for someone else to cast a vote, then there's injury for the legislator who's bringing the claim? Because I'm not saying that's necessarily wrong, but it seems to me that's effectively your theory, because your idea is our no votes would carry more weight if somebody who had a yes vote couldn't vote. And so something that makes it a little more difficult for that person to vote, say harder to show up to vote, anything that makes it easier for someone else to cast a vote seems like it potentially imposes an injury on somebody else who's casting a vote.
Your Honor, that is not our claim. Our claim is simply that if you assume, as you must, for purposes of standing, that proxy votes, if they are invalid, that counting an invalid vote, not a vote that never showed up and got cast because it was difficult logistically for that member of Congress or whatever, or that citizen to get to the polls, but rather, if as a matter of constitutional law, the vote itself is a nullity, it's not constitutional for it to be cast, which we are submitting is the case with proxy votes, then counting that vote anyway, that is what creates the dilution and the constitutional injury. I don't believe it would be, and I'll be honest, I hadn't thought through the point the court is making completely, but I don't think it would be hard to draw a line between votes that are, as a constitutional matter or a legal matter, illegal, and votes that are simply difficult. And in our case, and the only case before you, is that that counting invalid proxy votes dilutes the votes of all the valid votes, all of them that are cast, and that creates the injury recognized by this court in Michael. And
I don't think I understand why invalidity. I'm not necessarily saying that this means your standing theory is wrong. I'm just trying to understand the implications of it. I'm not understanding why invalidity of a vote gives rise to a different injury in kind than any time it's easier for someone else to vote, because the injury comes from the fact, as I understand it, the injury comes from the fact that the legislator who's bringing the claim would have gotten a result on the vote, but for the fact that somebody else cast a vote that ended up annulling the like happened in Cooper. It's that kind of injury that we would have won, except that somebody else got to vote who shouldn't have gotten to vote, or who cast an invalid vote, or whatever it is. But because they got to vote, the result that I wanted did not come to pass. That's the theory of injury as I understand it. And that would encompass, that's not the theory of injury.
No, Your Honor.
Okay.
That is an injury. That's the ultimate injury. Yes. From the counting of an invalid vote, or from the non-counting, if you will, of a vote that just couldn't get to the poll, if you will. That's the ultimate injury. But Your Honor, the injury that is before you now is that the very casting of a vote dilutes everyone else's vote if that vote is invalid and it doesn't count. Even if that vote, that invalid vote that was cast and counted was not decisive. Now, there have been many decisive proxy votes in the House thus far. Decisive, not in the context of yielding an actual law yet, but decisive in many other respects, including how the House organizes itself and the kind of powers and responsibilities that individual members have. But Your Honor, we would say that the injury, we believe this court in Michael and before it in Vanderjagt recognized, is the injury that flows just from the casting and counting of an invalid vote. And I think that this court's decision in Skaggs against Carl actually acknowledges that is the injury, regardless of whether the vote itself was decisive. Now, it's certainly true, and I'll subside in the hope that I have a little rebuttal time.
We'll give you a little rebuttal time. We will.
Thank you. But well, in that case, Your Honor, I think I've completed my point.
I do want to, please, Judge Rogers.
One sort of basic question. The theory here, as I understand it, is basically a geographical notion that because in history you had to be on the floor as a duly elected member in order to cast a vote, any change as to that geographical aspect is necessarily, I'm trying to put your words, not mine, a vote that cannot be counted. And you cite a number of authorities. I'm wondering, though, over history, originally everybody had to ride a horse. So only certain people who had a horse could get there. And snow or whatever might prevent that person from arriving. Then we got airplanes, we got trains. So a lot more people were able to get there than at the time of the founding. I'm wondering about this notion of 203 years. What the framers had in mind in terms of making certain that voters were duly represented in the halls of Congress. And your answer seems to be only if their feet are on the soil of the floor of one of the houses.
Yes, Your Honor. We think there's two very important supports for our argument that actual presence in the House or Senate chamber is necessary for the for an individual member to be counted towards a quorum or to cast a recorded vote. One is the language of the Constitution itself. And yes, it was written at a time when it was much more difficult, of course, to attend the sessions, but nonetheless, but it was a time when proxy voting was well known and was practiced in legislatures before the framing of the Constitution. But nonetheless, the framers, in one passage after another, from Article 1, as we say, to the 23rd Amendment, used words that make just pellucidly clear that actual presence was required for these purposes, Your Honor. And our point about history is simply that unbroken history for 230 plus years, the House has, up until recently, and the Senate even still, has obeyed the clear, what we would submit to you, Judge Rogers, is command of the Constitution's provisions that actual presence is necessary to cast a valid vote or to be counted towards the quorum. And yes, it is geographical in a sense, as you're suggesting. It's geographical in that, yes, the individual member has to be present. That's why in the history of this Congress, we've had members even essentially on their deathbeds rolled into the chamber in order to cast a vote.
Yes, I thought of that too. But I'm trying to understand the word presence and what exactly that means, because again, as the Chief Judge points out, getting a little into the merits here, the quorum requirement and the fact that there is a quorum at 12 noon doesn't mean there has to be an actual quorum, physical presence, at 3 p.m. when the vote is taken. That's the way the chambers have operated under their rules. And the fact that proxy voting existed and the Congress, the House, chose not to use it doesn't necessarily decide the question. That's what I'm trying to understand. You know, they used pen and quills. Well, we don't use that anymore. And so there is some movement here. And I want to understand this physical presence as geography, because it's, as they say, boots on the ground is what you're saying the founders required.
Yes, Your Honor, and to address the point about a quorum, the I think historical judgment from the Federalist Papers concerning why they chose to set it at a majority is further supportive of the proposition that actual boots on the ground, Judge Rogers, as you phrase it, was the understanding, the command of the Constitution, because there was a debate over what the quorum requirement should be, and a majority was viewed as one that best balanced the realities of the distance and the relative difficulties that individual members of the body would have to negotiate in order to be present and not be absent, so that they could be counted towards a quorum. Further, with respect to the quorum point, yes, Your Honor, it is true that if a quorum is established at noon on a legislative day, it doesn't mean that it must be established first by actual presence. There's simply no debate or dispute among the parties on that. And anytime any member suggests the absence of a quorum, it must be again established by actual presence. But it is true that once it is established, a presumption attaches, and the quorum is presumed to persist until such time as any member suggests to the contrary and requires that the actual presence of a quorum, as the framing goes, has to be once again demonstrated. But Your Honor, we would simply note that the practice of unanimous consent is one that is common to legislatures long before it was adopted by the bodies of our Congress as a necessary presumption and a method by which legislative bodies can proceed without constantly counting noses to determine and to establish and to prove that, yes, a quorum continues to exist.
So under your theory, and I won't persist, but just under your theory, if you view COVID as a plague, Congress could not operate.
Your Honor, no. We believe that Congress has operated throughout history, even in the presence of plagues that are worse by orders of magnitude, at least as we speak, than the coronavirus crisis.
Take my hypothetical. I'm just trying to push you here so I know how far your theory goes. There is a plague.
And
no one can convene in a geographic sense.
Your Honor, I think
under
that
the constitutional system, as I understand your argument, Congress simply could not function because no one geographically could get to the floor of the House.
Your Honor, that scenario, that hypothetical, Your Honor, I believe would result in Congress, having to find some way to gather in person, as it has in every crisis that it has faced throughout American history.
So my hypothetical is we have a new crisis. We haven't ever experienced this in the past. And there really isn't any disagreement in my hypothetical that the plague is such that the House and Senate have to shut down under your theory. I just want to understand under my hypothetical, and you're saying COVID is not such a situation. And I'll take that as a hypothetical. Is that the result of your theory here?
Your Honor, I have to give you the same answer that Jefferson, Hamilton, and Madison gave to Washington in 1797 in the yellow fever plague. And it was that, in Jefferson's words, even if the Congress has to meet in Philadelphia, the seat of government, in a field for one day before it moves its place of convening to a safer location, then that's what it must do.
Of course, his words have to be taken in context. They didn't have Zoom and other things at that point. I won't belabor this. Judge Walker has some questions.
Well, before my questions, I do want to follow up on, if I can try to give the answer to Judge Rogers' hypothetical. Assume that if anyone leaves their house, they will die. Assume that's the hypothetical. And my question is, does that mean that Congress simply cannot meet, according to your theory?
According to my theory, Your Honor, I believe that the Constitution will have to be amended to permit them to meet.
And the Constitution can't be amended unless two houses of Congress support the amendment with a supermajority, and if they can't meet, they can't do that, right?
And that may be a very good reason for Congress and the country to consider such an amendment in a time when it can take place.
Fair enough. The one last question on the merits before I want to go back to standing. The Supreme Court recently said in its Wayfair decision that one may be present in a meaningful way without that presence being physical in the traditional sense of the term. What do you think about that?
Your Honor, I think that statement was made in a very different context. It was made in the context of corporate presence, the presence of a corporation, and in particular, a retail corporation that has retail sales, even if it doesn't have an individual or an office present in a particular location. And a corporation can have many different places of presence. It can even have, and the court has struggled with how to identify a single place where a corporation is present. I think ultimately settling on the center of gravity rule. But a person,
Mr. Cooper, let me interrupt if I may. Do you think that I'm present for this oral argument?
Your Honor, I think yes. I think you're present in the sense that we are interfacing together through this medium. But, Your Honor, if your law clerk were sitting in your chair and were asking me questions by your proxy, you would not be present.
So you'd be fine with a House rule that allows voting by Zoom, correct?
Your Honor, I think that'd be that would fall under my same argument. It would be a different case. It would be a different case. There's no way to say that you're present. You're present if what's present is your proxy.
Okay. And I wasn't even going to ask about merits, but Judge Rogers got me all interested. So if I could ask one or two quick standing questions, and then I'll get out of the way here. You don't represent a House of Congress. You don't represent even an entire committee of Congress. Your clients are, I believe, all members of Congress from one political party. I guess it seems to me that this is yet another case where one group of politicians are sparring with another group of politicians, and they want a federal court to pick a side. Whether we view this under standing jurisprudence, political question jurisprudence, speech and debate jurisprudence, the principle behind those doctrines is that no court is supposed to be an instrument of partisan warfare. Tell me why I shouldn't view this case as a group of Republican representatives trying to get their way in Congress against a group of Democratic representatives.
Your Honor, to put this in the context of standing, I think you're bound by the Michael case. And that case, just as surely, had its partisan element to it, in which the territorial representatives were allowed to vote in the committee of the whole. It was a partisan objection.
I understand, Michael, and would I be interpreting your answer correctly if I interpreted you to be saying Michael says it's okay for one segment of politicians to use a federal court as an instrument of partisan warfare against another group of politicians?
No, Your Honor, that is not any way close to
I don't
home.
think that's what Michael says either. So I'm wondering how
And I don't want my argument
how is
framed.
that what's not going on here?
Well, Your Honor, what's going on here is one set of members of Congress are saying that they're being injured by a different set of members of Congress in terms of the actual value of their vote being compromised. And Your Honor, whether that breaks down, if I'm right and that is happening, whether that has broken down on a partisan basis, as one would probably expect that it might, should not stay the court's hand from, if we have standing, if the case is not barred by speech and debate, should not stay the court's hand from taking it up and according a remedy. This court.
Very good, Mr. Cooper. And that assumes that Michael survives reigns, and that question is well briefed by both sides. One last standing question. One of your clients is a constituent named, I think his name is Mr. Swayze. He's in a congressional district whose member of Congress did vote by proxy. So why does he have standing? How has he been injured by this rule?
Your Honor, our theory there is he's been injured because his representation in Congress has been subdelegated. Our point is that Mr. Swayze and the other citizens, voters in that district, have delegated their power through the representative that they elected to express their voice in the halls of the House of Representatives.
So then, Mr. Cooper, that means that every constituent in every district in the country has been injured, which now it starts to look a lot like a taxpayer standing case, which means no standing.
Your Honor, I want to call the court's attention to the Michael decision again, where the court addressed the widespread nature of the injury that was before it, the claimed injury before it, from dilution of the voting power of members of Congress. It attached to every member of Congress, and therefore it attached to all their constituents.
Very good. Thank you very much.
Thank you.
Thank you, Mr. Cooper. Unless my colleagues have further questions, we'll hear from Mr. Leiter, and we'll give you some time for rebuttal.
Thank you, Mr. Chief Judge.
Mr. Leiter.
Thank you, Your Honor. May it please the court, I'm Douglas Leiter, the General Counsel of the United States House of Representatives. Before I start, please just give me a moment to say that it is such an honor and a pleasure to appear in court with my friend, Mr. Cooper, with whom I've been friendly for several decades. Your Honors, I had a lovely, stirring introduction, which I'm going to pass because I want to jump right in and answer the questions that you have asked. If you want later, I can email you that wonderful introduction. The first point right off is to get to some of the questions from the Chief Judge. First, remember, Rangel has a very key quote. This court said, Congress's execution of internal rules is legislative. And so, as you know, and as the decision in Walker focuses on, is it an act legislative? And as this court has said any number of times, it doesn't matter who the actor is; it's the act. And so the Walker decision says quite a few things, as my friend Mr. Cooper has mentioned, but just above even the point that the Chief Judge quoted, at some point the court said, Consumers Union held that arrangements for seating the press in the House and Senate galleries were integral to the legislative machinery and thus were immune from judicial review by virtue of the speech or debate clause. So here, as Judge Contreras found, it's harder to think of something that is more integral to the legislative machinery than the act of voting. And remember, that's what this case is about. Congress, the House has made a rule, an internal rule about how members can vote. And so, again, as Judge Contreras found, this is as close to the legislative process as you can get. Mr. Cooper says that Consumers Union is not directly on point here because it did delve into other rationales. And it's, again, the Chief Judge's questioned that. And I just wanted to note at page 1348, this court said that it was looking at whether constitutional rights and therefore a question proper for judicial consideration necessarily is presented. We need not pause to consider such a formulation in the abstract, but turn to the effect of the speech or debate clause to settle whether, despite the claim of constitutional violation, tenuous as we have noted or otherwise, this case is yet non-justiciable. So I think that makes clear that that is holding of Consumers Union, and that was indeed picked up then in the later decisions such as Rangel.
So can I ask you, Mr. Letter, what do you do with Powell versus McCormick?
Yes, Your Honor. So obviously in some of these cases, it is difficult to draw the line. But in Powell, the Supreme Court drew the line at as I recall, the doorkeeper and maybe the sergeant at arms. It said they can be sued under the circumstances there where, remember, the House had said they were not going to seat Representative Powell. So he was not allowed to vote or participate or receive a salary in any way. And under those circumstances where he had been kicked out of Congress, that then was considered close enough that speech or debate did not bar a suit against those officers.
Does it come out differently? Does it come out differently if they let Powell do everything a member of Congress does, except they just don't count his vote?
So you mean you have a situation where Congress decides that the House decides it is not going to count any specific representative's vote? That very well might come out differently. The situation, it would be a situation of individual discrimination against an individual. It's possible, but obviously.
Really? Mr. Letter, is that really the position of your clients, that the majority of the House could single out a single member of the House and say, we will pay you, we will listen to you, we will let you have an office and a staff, we'll let you walk around and come on the House floor, but we will not count your vote, and you have no way, you have no remedy in a court?
Well, again, if Powell is controlling, then that suit would be cognizable. However, remember that the speech or debate clause was inserted into the Constitution by the framers.
But Mr. Letter, I wanted to give you a chance to say what you were about to say, but first, if you give me the answer to my question, it's not the same facts as Powell. Under the facts I gave you, would the new Powell, the new Representative Powell, be able to get a remedy from a court?
And you know, Your Honor, the first words out of my mouth in response are going to be, that's not this case. If there is individualized discrimination against particular members of Congress, that would pose a very difficult case and a very different case. However, as I was starting to point out, remember that speech or debate is absolute. So, for example, this court, the judges on this court have absolute immunity. It doesn't matter if I say, but you discriminated against me on the basis of my race. That is my claim. That is exactly my claim. And you all can say, that sounds good, and you may even be right, but we are absolutely immune.
So I take that, and if I'm understanding your answer, and my hypothetical would be a different case, of course, and you're not taking a firm yes or no on whether or not a court could decide that case. But I think I hear you saying a court probably could not provide a remedy to the PAL in my hypothetical.
Except the remedy, remember, there would be very likely a remedy for a plaintiff who came forward who was affected by a law. If there were a law passed and individual members of Congress were discriminated against, then very likely people who were affected by that law, they could sue, and they wouldn't sue the members of Congress. Remember, they would then be suing the executive branch, which would be carrying out the law. So there is a remedy.
Okay.
Your Honor has
even with the individual who brings the suit, if it's a speech, that's true for standing. That's always a way around, potentially around standing, because that's what happened with Reins and Clinton versus New York. But does that work for speech or debate purposes? Because if the individual is suing, the individual action would be brought against who? The sergeant at arms?
Because no, Your Honor, the question, the hypothetical that I was posing, Your Honor, is Congress, let's say the House says, we're not going to count any votes by women. Women shouldn't be here. We're not going to count their votes. And then the House passes a statute, passes a law. It comes into law. Somebody who is then affected by that statute could say that statute was unconstitutionally passed, and they would presumably be suing the executive branch, which would be enforcing the statute against them. So that was the remedy that I was posing.
Okay, so then can I just go back to Powell for a second? So then if we assume that the answer to Powell, the hypo that Judge Walker posed to you, if we assume that the answer to that is no, speech or debate is absolute as you described it, and therefore in a situation in which the remaining members of the House decided that Powell was not going to be able to vote, but he could sit, and then you can't bring that action because speech or debate would prevent a remedy there, then what's the difference between because Powell did allow the suit. So the difference is that you can't be excluded altogether, but you can be excluded from voting for speech or debate purposes. And if you're excluded altogether, there's no speech or debate problem. If you're excluded from voting, that there is.
Your Honor, what I was saying in Powell, the Supreme Court obviously believed that the combination of circumstances made it so that it drew a fine line. And it said under those circumstances where the member is being excluded and not paid, remember that was a key part of the decision, and not paid, that person can sue. This case, and so if the facts of that case change, would the Supreme Court come out differently? I don't know the answer to that. And
here's what Gravel says about Powell. Powell versus McCormick reasserted judicial power to determine the validity of legislative actions impinging on individual rights. And it seems like one thing that Gravel was doing is it's taking the three cases that have been discussed in the briefing, Powell and Dombrowski and Kilbourne, and at least in some measure, there's a lot going on in Gravel, but at least in some measure, there's a reference made to impingement on individual rights, usually third parties. Powell's a little different because it's hard to call Powell a complete third party, but what was at stake was individual rights, and according to the Supreme Court. And so is the theory behind the potential distinction between exclusion altogether and exclusion as to voting, that insofar as it's excluded altogether, that impinges on individual rights, insofar as it's excluded where you're included, but you're excluded for purposes of voting, then it transfers the case from one about individual rights to one about rights as a legislator. And
that's right.
I'm just looking for some theory that helps draw the distinction as opposed to just a factual distinction.
Right, Your Honor. And so that would be a potential theory. It may very well be, as the Supreme Court said in Gravel, my memory is it was saying that's a potential point, and that is. And so there would be, if under those circumstances the House chose to assert speech or debate, obviously it would be a very difficult case to determine. This case, again, there's no discrimination against anybody. Remember, that this method of voting has been made available to all members of the House. So wherever we draw the line, this case is nowhere close to it because it is quite different since there is no individualized discrimination.
Can I take you to standing for a second, unless I don't want to move off speech or debate too quickly.
Yes.
My colleagues have questions on that. Then let me take you to standing for just 1 second. So let's assume, I know you'll resist the assumption, but I'm just asking you to assume it.
Yes.
Assume that we think Michael is still good post-Reins. And I know you've got your argument that says Michael should be rethought after Reins, but let's assume that Michael's still good. If the rule in Michael were that not only do the representatives of the territories, not only are they allowed to vote, but in order for them to vote, they have to vote by proxy. And then another legislator challenges the ability of them to vote in the way that Michael came about. Then under your standing theory, would it be that insofar as they're challenging the ability of the territorial representatives to vote altogether, they're standing? Insofar as they're challenging their ability to vote by proxy, there's no standing.
So the first answer on Michael, and I hope I'm responding to your question, is Michael is obviously different because Michael adds more people to the denominator. It says people who we say cannot vote,
right?
They get added.
Right, but I'm saying that they can vote, but they have to vote by proxy.
Right. So then that makes it quite different, Your Honor, because then you're talking about is this court going to review rules set by Congress on how to vote? Now, it still might be a question of there might be standing there if there is individualized discrimination against some members. And as you know, the footnote in Reins leaves that open. And so it may very well be that would be enough to bring standing. So if Michael is still good law, if you start adding people to the voters, Michael would mean that there is standing for that. If you individually discriminate, Reins says that might allow.
I guess what I'm trying to tease out the following point to me, which seems like a question raised by your standing theory, which is that I know you've got this denominator notion that if you add to the denominator, then they're standing. But if the denominator stays the same, then there's not standing because the people who are complaining still got their 435th. But in a case in which somebody's not supposed to vote, but then they're allowed to vote by proxy, it seems to bring both of those together, because the person who's complaining, they're just saying, look, that other person shouldn't have gotten to vote. They shouldn't have gotten to cast this vote. Now you could say it in one or two ways. You could say, A, they shouldn't have been allowed to cast a vote at all because they're ineligible to vote. And then you could say, B, well, regardless of whether they were eligible or not, they cast an invalid vote. Still, that vote shouldn't be counted. And it seems to me your standing theory tries to draw a talismanic distinction between those two modes of argument. And I'm not sure I understand the talismanic distinction when you're talking about injury, because the person who's complaining about the vote is still being injured in the same way that somebody else whose vote shouldn't have counted got to be counted.
Your Honor, I think a more appropriate way to look at it, when I say more appropriate, I mean under the case law, is you don't have standing to challenge how somebody else who can vote does vote. For example, suppose there were, and I think this hypothetical is directly on point, and it ties in with one of the questions that either you or one of the other judges asked. Suppose the election board in a state says, there is a blizzard coming, so we're going to open the polls an hour earlier and keep them open an hour later. Under Mr. Cooper's theory, and I believe I heard him indicate this, he would say, well, but that vote under the prior rule would not have been valid. If you vote an hour after the polls close, your vote doesn't count. But the Board of Elections says we're going to keep open an hour later. Could anybody sue? Would anybody have standing to say, I'm planning to vote in the middle of the day. How dare you make the polls open an hour longer so that registered voters it's easier for them to vote? If the old rule applied, their vote would be invalid. Well, nobody would think that they're standing in that circumstance. So it's not a question of like in Michael, where you're saying, we're going to take some people who, under your claim, are not eligible to vote. They can't vote, whether they vote by proxy or by time, whenever. That's quite different from simply saying, we're going to make it easier. We're going to make the democratic process easier for people to vote, people who are otherwise completely eligible to vote. So I think that's a very clear distinction.
I understand the distinction. I guess it's not immediately apparent to me how much work that distinction does vis-a-vis the person who's injured, because it just seems to me they're injured in what could be described as the same way, which is that their affirmative vote isn't getting the same mileage because some other vote was counted that shouldn't have been.
Well, let me try it this way. Let me try it this way, Your Honor. I'm sorry.
No, that's all right. You
go. Let's put it this way. We don't believe that they are injured. And again, I think that the case law supports this because this opportunity is open to everybody, all the eligible voters. We're saying, okay, everybody who is eligible to vote. We're not making more people eligible. We're not doing that. We're giving you an additional opportunity or ability to exercise your vote. That's very different. And I don't think, and I'm fairly sure, Mr.
It just
Cooper,
seems like it's semantic, because in some ways you are making more people eligible to vote, because a predicate to casting a proxy vote is that the person has to say that they couldn't have been there, right? And
it says they're unable to vote. Now, remember, Your Honor, the person could say, this is a really important vote coming up. If I travel to Washington and go onto a crowded House floor, I might get sick and I might die. But I'm going to do it because you left me no choice. Now, I think that person is unable to vote in the way that in the House, we understand the proxy voting. So you could say, yes, fine. If there's no proxy voting, remote voting, I'll get there and you watch me die. Does that mean that that then changes things? So if what you're saying is what I think Mr. Cooper's clients are saying is, we insist, and the framers insisted, that everybody can only vote in one way, and that is even if it makes them vulnerable to death from a raging pandemic. That's it. That's what the framers meant. In addition, if I could add one more point, Your Honor, I know you didn't ask specifically about this, but I think it ties in very well. Remember, what we're arguing is Michael is distinguishable. And I know your hypothetical said, okay, suppose that Michael was not overturned by Raines. But remember, what Mr. Cooper is doing here is he's asking you to extend Michael to a different situation. And even if Raines did not expressly overrule Michael, surely it would be very strange for this court after Raines to extend Michael to a new factual situation.
You see if my colleagues have any further questions for you, Mr. Letter. Okay, thank you, Mr. Letter. I think we have your submission. If you have something else you want to say in closing, you're welcome to, but otherwise we'll let Mr. Cooper have his rebuttal.
Would you give me 1 second to just very quickly scan my notes, because I did jot down several things I was going to say. Do you mind, Your Honor? The one thing I wanted to do was the questions about, well, no, I guess never mind. Your Honor, I'm sorry, I rest.
Okay. Thank you, Mr. Letter. Mr. Cooper, we'll give you I think it was 3 minutes of rebuttal.
Thank you very much, Your Honor.
And Mr. Cooper, could I ask you to start, and then there'll be time for you to go from there. But assume that Michael was overruled by Reins. What's your best argument for standing in that case? Assume I think it was overruled. How can I still rule for you on the standing question?
If it was overruled by Reins, despite this court's many, many statements to the contrary, including Judge Rogers' recent opinion for the en-banc court in McGann, Your Honor, I would simply argue to you that the dilution, I would argue Reynolds against Sims, Your Honor. I'd argue Westbury against Sanders. I'd argue the census cases. Any time a valid vote is cast and is essentially canceled out by an invalid vote, there has been an injury in fact. And Your Honor, that is mathematically inescapable. And so that would be my argument to you, Your Honor. I'm not sure I'd have a case other than the classic dilution cases to offer you. Certainly, if Reins has overruled Michael, my job is a whole lot harder.
And I don't want you to have to spend your whole rebuttal answering my question. So I'm good if the other judges are.
Let me speak to the Wrangle case mentioned by Mr. Letter. What he's quoting there is a parenthetical after the citation to Consumers Union. And the parenthetical says Congress's execution of internal rules is legislative. Well, that parenthetical from Wrangle simply can't be squared with the case that it cites, Consumer Union. It is a drive-by comment, and the court can't place a stock in it, even if it could, because Consumers Union, Your Honor, recognizes this temporal distinction. But even if it could, it would be refuted by the Powell case, which also was the execution of internal rules relating to the discipline of a member of Congress, just as Wrangle was. Secondly, Judge Walker, you're hypothetical. I think I heard my old friend, Mr. Lutter, basically say that, yes, there'd be no standing if Mr. Powell had been stripped of nothing other than his right to vote. I think I may have also heard him stand up to the hypothetical that I've offered, an extreme one, I admit, that you have a rule passed where women cannot vote. And he makes the point that it's absolute. Your Honor, I don't think that his points can stand up to that hypothetical. And it wouldn't change one bit, Judge Walker, if that decision to strip Mr. Powell of his vote was an act of partisan spite. It wouldn't matter. I see my 3 minutes has already fled by, Your Honor. So I'll thank the court for its time and attention.
Thank you, counsel. Thank you to both counsel for your arguments this morning. We'll take this case under submission.
Thank you very much.
Case number 20-5032, Gunay Miriyeva et al. Appellants versus United States Citizenship and Immigration Services and Kenneth T. Cuccinelli II, Director, U.S. Citizenship and Immigration Services, in his official capacity only. Ms. Wallenberg for the appellants, Ms. Reno for the appellees.
Morning, counsel. Ms. Wallenberg, please proceed when you're ready.
Thank you, Your Honor. Good morning. May it please the court, Jennifer Wallenberg for appellants who were plaintiffs below. I've asked to reserve 3 minutes of my time for rebuttal. Plaintiffs are veterans who were recruited into the United States Army under a Department of Defense initiative intended to provide certain non-citizens, those with specialized skills needed by the U.S. military, They were promised an expedited path to U.S. citizenship in exchange for service during a time of designated hostilities. Plaintiffs served for some period of time before they were discharged. They weren't discharged because they did anything wrong. They weren't discharged because the Army didn't want them to serve anymore. They were discharged for medical reasons, either physical ailments that occurred as a result of their service or that were discovered during regular Army medical exams. Plaintiffs each received what's called an uncharacterized discharge. The military treats these discharges as under honorable conditions discharges for purposes of military naturalization. The military naturalization statutes say USCIS is supposed to defer to the military on this exact question, but USCIS has a policy that says that it's going to treat these discharges as disqualifying for military naturalization purposes. The lawfulness of this USCIS policy was not decided below because defendants maintain that 8 USC 1421 is a jurisdiction stripping statute. Defendants are wrong, and this district court has subject matter jurisdiction to hear plaintiffs' challenge of the USCIS policy. If defendants have their way here, the lawfulness of the USCIS uncharacterized discharge policy will never be decided by any court. There is a presumption that agency action is subject to
I don't
judicial
understand
review.
that. Why, can I ask, I don't understand why it will never be decided by any court, because if the normal administrative review process is followed through to its conclusion, and then the agency denies naturalization, and then that gets de novo review in a district court, one of the arguments that can be made in the district court is that the grounds for denial are wrong legally. And then the district court has to answer that. So there will be an answer to the question of whether what you're calling the policy is valid. It'll just be in a case-specific instance involving a particular individual whose petition for naturalization will have been denied.
Your Honor, that's one of the problems here is that USCIS is taking the position that no court could ever tell it that its policy is unlawful and do anything about it. And so that
I don't think we can ask USCIS about this, but I don't read them to be taking the position that no court could say that the grounds that would be asserted for the denial are invalid. I think the question is the scope of relief that the court could answer, that the court could hand down. And that we may have some questions about that too. But in terms of whether the legal argument you're making, which is that it's just wrong to deny this uncharacterized class ability to gain naturalization, it seems like the district court would have to decide that question if one of your clients posed it in the context of a specific denial of naturalization. That would be the argument you'd raise as to why the agency got it wrong, and then the district court would have to either agree with you or disagree with you.
We agree with you, Your Honor, that a district court should be looking at that. If it's not decided, some district court somewhere should be looking at that and making that decision, and should be looking at whether this policy or treatment is lawful or not. The USCIS has said that the relief is limited in a 1421C action, and therefore what would happen is that in an individual case, a court could decide that the policy is unlawful, or could decide that it should have gone through notice and comment rulemaking, but that each individual would have to, thereafter, would still have to go through a futile administrative appeals process that's very long, get a denial decision at the first step, get a denial decision at the second step, and then file an action with a federal district court. And they're saying that they would have to do this even though that's not Congress's intent. Congress has the intent in creating all of this and creating the structure was to make the process more efficient, was to...
Well, I mean, that kind of argument about how cumbersome the administrative process could almost be made any time you have this kind of Jarkizi situation. And Jarkizi itself, I think one of the arguments that was presented was, look, why do I have to go through this entire administrative process? I mean, I've got a legal claim that's a perfectly teed up legal claim. Why don't you just decide it and relieve me from this miserable experience of going through this administrative process? And that, but the Supreme Court's cases and our cases don't give effect to that kind of argument, because where Congress has set up an administrative review scheme supplemented by judicial review at the back end, then it's incumbent upon somebody to explain why it is that that process shouldn't be followed through. It's not, the burden doesn't go the other way. it goes in favor of thinking that that's the specialized process that you would normally pursue to its conclusion.
Well,
Even though it's cumbersome, it can be cumbersome, even though it takes some time. That's just what Congress has laid out.
Your Honor, I want to get to that exact question in a moment. Just before I get there, I would say that the clear and convincing evidence and the burden of showing that there's clear and convincing evidence really is on USCIS here, because we have a statute that says such denial. And the question is, what does such denial means in the first instance? And that's already been answered by the McNary case that says that's not about policy challenges, that's about the individual application challenges. But to get to your exact question, the Jarchese case and the progeny of Thunder Basin are really about a different scenario. The cases there are about an administrative process that is really a substitute for a district court action. And the question there is, should there be a separate district court action allowed in certain circumstances? And the administrative process, as you noted, is then backstopped by a judicial review at the Court of Appeals. And sometimes the administrative process does not allow for every question to be answered. If the administrative process can't answer a constitutional question, but courts have said that's okay because we have the Court of Appeals at the back end. But the key difference here is that this administrative process could never resolve any of these applications in a way that will not make the district court action somewhere necessary, in a district court action looking at the policy and the lawfulness of the policy itself. And the reason I say that is, in the Jarchese case and in all of these other cases, something could have happened at the administrative agency level that would have made those cases basically go away. And the questions that were being brought to, or trying to be brought to a district court, unnecessary at that point. There is nothing that can be happen or be added at the district court level, at the administrative appeals level, in this case, that will matter. And every administrative appeal action and every administrative agency action about uncharacterized discharges is meaningless and offers nothing and adds nothing to this question.
But then you still get to raise the claim in district court. I mean, first of all, I'm not sure that that's entirely the case, but the point is there's still district court review at the back end of that, in which you can make the exact same legal argument that you're making now. Well,
there isn't district court review for everyone, Your Honor. I mean, one of the things that USCIS
who can't get it? If your naturalization has been denied by the agency, who's ineligible to get district court review?
Well, and that's the way the USCIS is very careful about how they describe this in their briefing. And they always say when the application is denied, but not every application gets denied. Some of the applications go directly to a district court after failure of USCIS to act within a certain number of days.
Well, that's a good thing from your perspective, because then you're going directly to district court. So why is that a problem?
Well, the question is, if 1421C is meant to be the only and exclusive avenue for these kinds of reviews, how do they explain this other avenue? And through this other avenue, does that district court have the same ability to look at these grounds and the same relief that could be provided there? Because what was a focus of the government is that 1421C says things about there actually being APA review available and it being
even in the one where I think it seems like a little bit of a sidelight to talk about the direct review in the district court where the agency hasn't taken action. But even on that one, I think the district court can remand it, right? It's not that the district court has to, as I understand that statute, I believe that statute allows the district court just to send it back and to tell the agency to resolve it, right? And so in the normal course, put that statute aside. If we could just put that statute aside for a second, in the normal course, including I think in a couple of the clients you're representing here, the naturalization is denied by the agency, and then under 1421 it goes to the district court, and then the district court takes a de novo look at whether naturalization was correctly denied. And then in that situation, you have the exact same legal argument you're presenting now. It just gets resolved in the context of an individual's application.
It gets resolved in the context of an individual's application. Just to make one more point on the 1447B, Your Honor, remanding it to the agency isn't really an alternative in those cases because the agency can't do anything with this question. The agency, through the administrative process, cannot decide whether its policy is unlawful or not. The supervisors who are making those decisions can't overturn the USCIS policy. So the only thing that's going to happen if it gets remanded to the agency, so then it can go to a 1421C action, is more delay.
But then ultimately it goes to a district court. And first of all, I'm not even going to talk about what happens for the agency, because I think we have cases that say that it can still be helpful for it to go before the agency. But just put that to one side. At the end of the day, it still gets to a district court, and the district court still resolves the exact same legal question that you're presenting here. Isn't that true?
They don't resolve the exact same legal question. The question isn't resolved. And if you're
why not?
looking at
Because why wouldn't you argue in the 1421 action before the district court that naturalization was wrongfully denied because it was based on this category of uncharacterized as falling outside of honorable? And that's just wrong as a matter of law. It shouldn't be done that way. The agency's wrong to think that it can cordon off these people and prevent them from eligibility for naturalization. They should be eligible. And then the district court has to decide that question de novo.
And it decides it for the individual, and right. The individual may get naturalized, but you still have an agency policy, a federal agency policy, that equates that individual's discharge with an other than honorable or a misconduct type discharge. That's still out there. So it doesn't solve all the problems for this individual. Even an individual getting naturalized still has this reputational
But
harm.
Even in this case, I mean, if you bring a case, any case that's brought before a district court, when a district court addresses whether it was valid for the agency to deny naturalization on the basis of this uncharacterized category, that opinion just has the persuasive force that that opinion has. It's not binding on another district court. It's not binding on a court of appeals. It's just a legal proposition that results in a conclusion for that case. It's the same whether, depending on what happens in this case, it's as it would be in a 1421 action. It's just that you get a district court who reaches a resolution based on a principle of law, and then we'll see what the effect of that is.
Right, and Your Honor, let me present a hypothetical, because I think the uncharacterized discharge action is a little bit hard to get hands around. But if USCIS put out a policy and said it was going to interpret the term person as being only females, so only females are persons under the INA, and they put that out, and there were thousands of male naturalization applicants who were seeking naturalization, and because of that new interpretation or that policy, would not be able to naturalize. And they have to, each and every one of them, according to USCIS, would have to go through the individual naturalization process, which can take years. It can go through the administrative appeals, get the denial, get the second denial, and then bring it to a federal district court. And what you just said is that that court could say that policy is unlawful. It's discriminatory on its face. And but according to USCIS, that court could just say that, but it would have no precedential effect for any other applicant. And USCIS for the next 100 years could make every male naturalization application go through that same burden and that same process, even if every court across the nation said it was unlawful. And so there is a difference between issues that are individualized and particularized, and that an agency through their administrative process could address, and it could change the outcome, and individual and issues that are collateral and that won't result in necessarily.
Let me ask just one more question, and then I'm done. I think I'm done. So I won't belabor the point too much more, but as I read the statute under 1421, the scope of relief that's available to the district court is the same scope of relief that's available in any APA action, because it says the review of such an before the United States District Court for the district in which such person resides in accordance with Chapter 7 of Title 5. And so it seems to me that a district court in a 1421 action, regardless of what USCIS says, we can talk about that, but with USCIS, but the district court relief is commensurate with what's available to any district court handling an APA action. So then it seems to me that if you, at some point you need an injunction because district court after district court across America is reaching the same resolution, but the agency, stubbornly insists that it's going to continue applying what 97 district courts have determined is an invalid policy. well, then maybe a district court can enter an injunction in the same way that any district court handling a case under the APA could enter an injunction. If that's true, then even your point about relief being differential, I think, goes away. Is that right?
We agree with you in terms of your reading, Your Honor. And we think that a policy being set aside is available to a district court under a 1421C action. Obviously, as you know, the government has taken a different position. I think it still goes back to the question of then whether somebody has to bring it through a 1421C action. And we don't think that the language of the statute, which is under McNary, is what controls here. And under the General Electric view of McNary, says it can only be brought through a 1421C action.
Okay. Thank you. I want to make sure my colleagues don't have questions for you. I monopolize the time. Oh, sorry, Judge Rogers.
Here is to bring the General Electric case as the basis for prevailing. And your opponent says, well, that was a different statute. And so General Electric doesn't apply here. And I want to understand your response to that, but I also want to understand whether your basic position is your clients do not deny and never have denied that their applications were denied. So there's no issue for the administrative agency to resolve. And even though you may raise before an administrative agency that the USCIS policy is invalid because it's contrary to the statute as a matter of law, the administrative person has no authority under the administrative scheme to grant you relief.
Yes, Your Honor, that's correct. That's the key problem. You mentioned the General Electric case, and we're not comparing the General Electric case set of facts or the statute at issue there. With our case, what we're pointing to in the General Electric decision is its reading of McNary, and that McNary used the text first. And when it found that the language "such a denial" meant only an individual application and not practice and pattern challenges, that's the exact same kind of language that is at issue in our case. So that's how the General Electric case comes into play here, by its reading of McNary and then looking at the McNary statute, which is almost exactly like ours. In terms of what the agency can do here, the cases cited by the government, they are talking about different statutory schemes, and they're talking about situations where the administrative agency action that is trying to be avoided in those cases, which is not the scenario here, but in those cases they're trying to avoid an administrative agency action, but the action could itself change the whole posture of the case and make it unnecessary and make the challenge that would then go to a court completely unnecessary. That will never happen here. There is nothing that will happen at the administrative agency level that will change this USCIS policy and change the outcome of these individual applications. And we know that because now 2 of the plaintiffs have been through the entire administrative agency policy process, and their denials of at that level say and refer to this long-standing USCIS policy.
So your options are, in your view, only to go directly to the district court as an initial matter under the APA, or I suppose file a petition. I don't know what you file before the agency and ask them to. It's not a petition for rulemaking, but how they change their policy.
There is nothing provided in the INA or otherwise to ask the agency to change a policy. The only path through the agency is just on the individual denials, and policy changes, even with respect to issues impacting naturalization denials, are brought against USCIS on a regular basis through an APA action.
So as I read USCIS's brief, they just don't respond to that. They just treat it as, in a footnote, factually distinguishable. And they don't respond to your legal argument about why General Electric is key in this case. Is that the extent of what you think is your best argument?
Well, I think it's the first step, and that if you take that first step and do the statutory analysis and it doesn't show that Congress intended this to strip other courts of jurisdiction, that's the end of the step. But I don't think it's our only argument, but I definitely think it's the first and the foremost argument is that the statutory language matches the language in McNary meant to only apply to individual applications. And this is clearly not an individual application situation. But you go on to congressional intent and to the legislative history, and you'll find that the same is true there in terms of what Congress must have intended to be the situation here, and how it would not make sense to and not serve Congress's goals to make individual applicants for the foreseeable future go through this process and go to courts time after time and potentially have different results and therefore different standards for naturalization applied to applicants in the same position.
So one of the points that USCIS makes is that in your complaint, you are not limiting the relief to setting aside this policy. In fact, you're asking for individualized relief for your clients. What response do you have there?
I think the simplest response is just to go back to the complaint and look at the complaint and the language of the complaint. Well,
that's what counsel was quoting. In other words, I'm trying to understand how, given the Supreme Court and our court for years have said, where Congress has a comprehensive alternative process for handling a matter, that process has to be exhausted. And as this case points out, the male who started out in this case actually got some relief where the agency changed its mind. But certainly Congress could have, in my view, understood that an administrative process hopefully would resolve matters and eliminate this backlog that was in the district court, but maybe not all matters, so that as two of your clients have done, they have filed these individual actions in the district court, presumably raising this legal challenge. And those cases have not yet been dismissed. I'm not suggesting they will be, but they haven't been dismissed as of yet.
Correct, Your Honor. The motions to dismiss that the government filed claiming preclusion based on the lower court's decision here have not been decided.
Right. Okay.
Your Honor, to pick up on a point that you made in terms of the individual plaintiff in this action that now the action is really not applicable to, it's a very different situation than some of the cases that the defendants here have cited, and in a very important way. You said that the agency changed its mind. The USCIS changed its mind, not on the policy or the application of the policy to that plaintiff.
No, I understand, but he got relief, so his application wasn't denied. That's all I'm getting at. That right. It was not a dead end necessarily for everybody.
It is a dead end for everyone who has an uncharacterized discharge. What happened there was that the Army made a mistake in issuing that discharge and then had to revoke that. And so he understand
that's relief. Yeah. All right. Anyway,
but that's not going to happen with respect to any of the medically discharged veterans, because right. The Army's position is that medically discharged veterans aren't physically capable of continuing to serve and therefore can't be reinstated.
Right.
And so there is no prospect of the Army changing its mind and retracting the uncharacterized discharge. So the policy itself and the application of the policy by USCIS doesn't change, and there is no hope for any kind of administrative relief for any of those medically discharged MAVNIs with uncharacterized discharges, which is different than the supplemental notice that the defendants provided earlier this week of a Second Circuit case called Moya.
I think we have that that distinction down. And let me just make sure my colleagues don't have additional questions and then if not, we'll hear from Ms. Reno and we'll give you a bit of time for rebuttal.
Thank you, Your Honor.
Thank you. Ms. Reno?
May it please the court, Catherine Reno for the government. This case presents the very narrow question of whether 1421C precludes the DC District Court from hearing plaintiffs' claims. Notably, their claims can and are being heard in the district courts where they reside. The DC District Court properly dismissed based on lack of jurisdiction after conducting the two-step Thunder Basin analysis and finding that plaintiffs' claims had to be raised in a 1421C action. Given the 1990 Immigration Act's comprehensive review scheme, which provides a rare, if not unique, scope of district court review, the plaintiffs simply cannot overcome the presumption that Congress intended 1421C to be the exclusive means of judicial review of naturalization applications. So plaintiffs move the goalposts. They attempt to supplant Thunder Basin and Jarkizi with a standard from cases where judicial review was completely foreclosed. Cases like Guerrero, Lasprilla, Make the Road, and McNary. In McNary, the plaintiffs could only get judicial review if they voluntarily surrendered for deportation. And the Supreme Court found that plaintiffs are not required to bet the farm in order to get review of their claims in that manner.
So is your position that in General Electric, this court misread McNary?
No, Your Honor. General Electric is distinguishable because the claims there truly were collateral. And because they were collateral claims, the Thunder Basin framework didn't apply. There, GE raised a pattern and practice claim about the way that the EPA was administering the statute, saying that it was administering it in a coercive manner. Therefore, ruling in GE's favor would not have invalidated any particular UAO issue there.
Isn't that the argument that's being made here?
I'm sorry, Your Honor, could you repeat your question?
Isn't that the argument that's being made here?
The plaintiffs are making that argument, but their claims are absolutely not collateral. It's
not collateral to what?
To their, basically, they're attacking the legal reasoning for the denial, but that is inextricably intertwined with a challenge to the denial itself.
But if the agency has no authority to deal with the legal reasoning.
The Supreme Court in Elgin addressed that and found that it wasn't significant that the agency may not be able to find a statute unconstitutional or otherwise maybe dispose of the constitutional claims as long as the claims eventually made their way to an Article III court. And that is exactly what would happen in this case, and in fact has happened for two of these plaintiffs. The district courts where they reside are hearing these exact claims. And those district courts have a very generous and comprehensive scope of review. They will look at plaintiffs' claims de novo. They can, if plaintiffs request, they can hold a hearing de novo. They can make findings of fact and conclusions of law. This is an incredibly comprehensive judicial review scheme that Congress has enacted in the 1990 Immigration Act. And for similar reasons, McNary is distinguishable because that involved a collateral claim.
Can you talk about the scope of relief that's available to a district court? Is there a difference between the relief that could be ordered by a district court handling an individual case under 1421 and the relief that could be ordered in an APA action if one were to be permissible, where the plaintiffs challenge the validity of the grounds for these denials on the basis that the agency is misconstruing the law and treating the uncharacterized category as falling outside of eligibility for naturalization under 1440.
Just to clarify your question, Your Honor, do you mean if, for example, this court were to find that the DC District Court wrongly dismissed and actually did have jurisdiction and
Right.
the case did,
Right, because as I read the statute, what the district court does in that situation then is to apply the APA.
That's correct, Your Honor. And in a 1421C action, that would not allow for national class-wide type relief. Those 1421C claim would offer individual relief. So even in this case, plaintiffs didn't bring a class action complaint.
Right. So let's just take the case of an individual. Suppose that instead of having 4 individuals, there was 1 individual that brought the claim in DDC. And then suppose that let's just assume that DDC can go forward with that action. And it's an APA action. Is the scope of relief that the district court can order in that action different from the scope of relief that a district court outside of DDC under 1421 could order, given that under 1421, you just incorporate the APA?
Well, 1421 has a more generous standard for plaintiffs. So in fact, it would behoove plaintiffs to bring that in a 1421C action because the court would have de novo review. Whereas,
what about the scope of relief?
Relief, right. Yeah, thanks.
So if it was not pled as a class action, again, it would just be individual relief.
In other words, the plaintiff here argues that in an APA action, the district court could set aside the policy, period.
Well, that's correct.
Arguing in the 1421C action, the district court could not do that. Is that your position?
No, the district court could provide that plaintiff and say, in this case, the court, USCIS acted unlawfully and find it, but it would be limited to that plaintiff. So
the district court could not order that the policy be set aside, only that it cannot be applied as to this plaintiff.
That's correct, because
could the DC District Court do that in an APA claim? Let me try to be more precise. Could the DC District Court in an APA claim, assuming it has jurisdiction, set aside the policy as applied to everyone in the country?
No, it could not, because this case was not pled as a class action. Assuming plaintiffs had this.
Right. So the scope of the remedy in the 1421 case and the scope of the remedy in an APA case brought in DC is exactly the same.
It is the same. It would be an individual relief.
As long as it's an individual plaintiff in the DDC action and not a class claim, then it seems like we're talking about the same scope of relief. Even under you as the government agree with that, right?
Yes.
The same scope of relief. Okay.
Ms. Reno, can I ask? Sorry. Go ahead.
Go ahead, Judge.
No, please. I was going to change topics a little bit.
Well, I just want to be clear that in this circuit, the district court in an APA claim would have the authority to do more, at least as to anyone who sues within that district. In other words, by saying that the policy is invalid, so anybody else coming into the DC district court who is properly before that court and the court has jurisdiction, relief arguably could be broader so that USCIS could not apply the policy as to someone who is a resident of the District of Columbia.
That would be the same in, say, the Eastern District of Kentucky.
No question about it. I'm just trying to clarify scope of relief. It's not necessarily just an individual plaintiff relief under the APA.
Sure.
Apply as to anyone who comes in the state of Kentucky under challenging the policy. That's all I'm getting at. But let's go on. Judge Walker has some questions.
I was just going to say, Ms. Reno, that as I understand it, in the case of Ms. Miriyeva, I may not be pronouncing that correctly, she signed up to serve this country, and then after some service wasn't able to because a lump was found in her breast. And the following happened to her between, I've got the timeline here, October 2018 and February 2020. It's 16 months. The CIS approved her application for citizenship. Then it refused to administer the oath to her. Then it scheduled the oath for her. Then it again refused to administer the oath to her. Then it rejected her application. Then it approved her application for the second time. Then it refused to administer her oath for now the third time. And then it rejected her application for now the second time. I think you're right on all the jurisdiction stuff and on how this particular case should come out. But with regard to your client, USCIS, is that how things are run there?
Well, Your Honor, it's also important to consider that this applicant also submitted conflicting forms. So she
was it her doing, or was it that the Army gave some conflicting codes, information, details?
Well, USCIS was evaluating, the paperwork that it received, and two of the forms.
So you're saying it's her fault that 16-month roller coaster of yes, no 14 times happened?
It's I don't want to say it's anyone's fault necessarily, but USCIS did certainly receive conflicting information as well. It wasn't as if it was changing its mind based on static information. It was receiving different information and it was responding accordingly. But this case isn't about the merits. It's simply about whether the DC District Court had jurisdiction to review plaintiff's claims, and it did not, because Congress's framework was meant to be exclusive, and plaintiffs cannot overcome that presumption.
I agree.
Thank you, Ms. Reno. If my colleagues have no further questions, then
Thank you, Your Honor.
We'll hear from Ms. Wallenberg for rebuttal. We'll give you 2 minutes back for rebuttal, Ms. Wallenberg.
Thank you, Your Honor. Just to follow up on Judge Walker's last point, in terms of the conflicting forms, it was not that she provided any conflicting information, and it was what the Army provided to her and she provided to USCIS on a timely basis. One part of your scenario that wasn't quite in the right order is she was actually approved for naturalization and supposed to be scheduled for an oath ceremony before she was discharged, and USCIS failed to do that. And then it was only because she was discharged that she became no longer eligible to be naturalized. In terms of the conflicting information, though, and whether that's how USCIS runs, it is how USCIS runs, because during that same period of time, we had 2 federal court class actions, related actions to this matter, that were pending, where USCIS and DOD were co-defendants, and reassured that court on multiple occasions that USCIS had a direct liaison at the Army to clear up and clarify any issues with respect to N-426 forms. And USCIS apparently did not select to use that liaison despite the representations to the lower court. But getting to the question that's really important here, 1421C is not a jurisdiction stripping statute for these purposes. The General Electric case said that McNary looked at the language of the statute first. There's nothing in the language of the statute or in the statutory scheme that would say that jurisdiction is taken away, that a court cannot review this under the APA. Even if you wanted to consider it that way and look at the McNary case and some of the other elements that that court mentioned, these individuals are not lawful permanent residents. They face a lot of the same harms and challenges and risks that other individuals face that lawful permanent residents who are in most of these other naturalization cases do not face. And then one thing that's important to question here is when asking the government about the relief that's available, the question seemed to focus around, well, if they had brought a class action claim, that would have been different. But how, under this analysis, their analysis, could a class action claim or an organizational plaintiff ever bring a claim, because they don't have a denial to bring through a 1421C action. So this analysis would preclude class action claims and would preclude organizational plaintiffs, and would allow and insist that thousands of individuals would have to challenge policies over and over and over and over again, because it can never be addressed in any other fashion. And that just can't be right or Congress's intent. And I know my time is up, and thank you so much for your consideration.
Thank you, counsel. Thank you to both counsel for your arguments this morning. We'll take this case under submission.
Case number 08-1065, State of New Jersey Petitioner versus Environmental Protection Agency. Ms. Morelli for the petitioner, Ms. Brown for the respondent, Ms. Broom for the intervener.
Just going to switch my light real quick to see if I can fix this. Hold on. Apologies for that. Lisa Morelli for petitioner, State of New Jersey. I'd like to reserve 3 minutes of time for rebuttal. May it please the court. EPA's revised reasonable possibility record-keeping rule remains defective and should be set aside. It is arbitrary and capricious because EPA did not do enough to address the enforceability issues identified by this court in New York versus EPA by not requiring sources to retain and report pre-change emission calculations. In rejecting the original rule, this court took issue with the fact that sources had no obligation to retain records, let alone report those records to or projections to permitting authorities. The revised rule with its trust us applicability scheme does not correct this defect. EPA's rule forces authorities to police NSR using post-construction monitoring data. This is not pre-construction review. In contrast to a straightforward show us your work rule, the reasonable possibility rule gives sources unfettered discretion.
Ms. Morelli, with apologies for the interruption, I want to start with standing if I could. And I also will apologize in advance. This is going to be something of a long question, but standing wasn't briefed as extensively as some of the merits questions. And so I'm going to share where I think the case is on standing, and then I want you to have every opportunity to tell me where I've gone off track if you think I have. Clapper says that the standard for standing is that the injury has to be certainly impending. In a footnote, it says that the substantial risk standard may survive. Possibly that substantial risk standard is lower than certainly impending, and Susan B. Anthony case uses the substantial risk standard. Maybe that's confined to the pre-enforcement cases, maybe not. If it's not, and if it survives, and if it were to apply here, you still can't rely on an attenuated chain of inferences necessary to find harm. That's from Clapper. You can't rely on speculation about the unfettered choices made by independent actors, not before the court. That's from Clapper. You instead have to plead and prove concrete facts, showing the actual action by the defendant has caused a substantial risk of harm to you. Now, in Mass v. EPA, Massachusetts was able to point to specific cars. It was easy. It was all cars, but they could point to specific cars and say these cars are emitting a pollutant, and that pollutant is making a specific part of our land, our coastline, recede. So the specific cars were causing our specific coastline to recede. And the science said that that was happening at the moment, and the science said that that was also going to continue happening. Here, by contrast, EPA has already banned the pollution that you think should be banned. You say you're injured because EPA has not made it hard enough for a source to evade the EPA's standard. But you don't point to any source that will certainly, to use Clapper's words, evade the ban, or that is even likely to evade the ban. I didn't see any specific sources in all of the briefing in this case that you say this source is going to cheat and evade the ban. So I don't think any source's evasion is certainly impending, and I don't think there's a substantial risk that any source will evade the ban. And your theory of standing, if I understand it, instead goes something like this. It involves, I think, up to 7 assumptions. You assume that some unspecified source will say there's no reasonable possibility of a significant emission. You assume the EPA will not catch them when they cheat. You assume that no other authorities will catch them. You assume the EPA would not have granted them a permit for the significant emission. You assume that the extra pollution will reach New Jersey. You assume that someone in New Jersey will be exposed to the extra pollution, and you assume that that person will be injured by the exposure. I think that's a lot of assumptions. It seems like an attenuated chain of inferences necessary to find harm, to again use Clapper's words, which you can't do. And it also seems like, in Clapper's words, speculation about the unfettered choices made by independent actors not before the court, which again, Clapper says you can't do. I know you disagree with that, and I want you to be able to pick it apart piece by piece and tell me everything you think I got wrong.
So I'll try to address the questions that you raised, your concerns. With any type of rule or statute that requires an entity to take certain actions, you're never going to be able to predict in advance for sure whether that source is going to comply or not. So there's always going to be, some element of what the source is going to do. You try to ensure they will comply by enabling one, as we say here, permitting authorities to be able to check what the source is doing. So there is some assurance of compliance. As far as attenuated circumstances, and this is in one of the declarations we submitted, there's no question that most of New Jersey's air pollution comes from upwind, out-of-state sources, something on the order of 70%. So without question, we are impacted by what facilities upwind and out of state of New Jersey are doing. And there are a lot of those facilities that are upwind of us. For all these facilities, if they are, if the enforcement ability of their own permitting officials are hampered, to the extent that they can't even find out if the source has undertaken a modification in the first instance, then yes, that will have a direct impact on New Jersey, because those sources that are undertaking these changes are not submitting the information to permitting authorities that they need to evaluate NSR compliance, and they're not able to ensure that NSR requirements are met, which includes installing pollution controls if required.
Thank you for being patient with my question and for the thorough answer. I'm grateful for it. Along the lines of standing and injury and redressability, let's assume that there is a source in Pennsylvania, a specific plant, and that plant is cheating and polluting, and New Jersey is injured by it. What can New Jersey do to, if they find out that the EPA is, if they find out that cheating is going on, what can New Jersey do to that plant that's not in New Jersey?
So New Jersey has the ability to bring a citizen suit action under the Clean Air Act. and they can sue the plant. In fact, we have done that. We have done that with multiple power plants, in fact, located in Pennsylvania, as well as other upwind states in the Midwest. So they have that option. They could petition EPA under 126 if they believed that, or I shouldn't say believe, they would need evidence to show that emissions from that plant were resulting in a NAAQS exceedance, an exceedance of the National Ambient Air Quality Standards for a pollutant that was affecting New Jersey's air quality. So those are the avenues that are generally available for out-of-state sources.
I want to turn just a little bit to the merits now. I'm concerned that almost everything you asked the EPA to do in your comments after they proposed the 2007 rule, I'm concerned that EPA may have done either everything or at least almost everything that you asked them to do. So I looked at, I've got your comments here, and with regard to the percentage increase trigger approach, I'm at JA50. It has, and that's the approach that's at issue on this case now. It talks about demand growth in almost every paragraph. The first paragraph just summarizes what EPA did, and then the second paragraph begins to criticize it. I'm at JA51 now. It says that the EPA's approach is bad because it won't address demand growth. And then the third paragraph there says it's bad because sources can exclude product demand growth, and it will be often difficult to separate demand growth from other emissions. And then it continues to talk about increasing demand growth, talks about the New York case, and it says that EPA quotes the New York case. Now I'm on JA53. It quotes the New York case, but it didn't address the New York case because it does not address this problem. And the problem there is referring to, again, the inclusion of demand growth, or the exclusion rather of demand growth. And the next paragraph says a source wouldn't trigger record keeping by excluding demand growth, and it's often difficult to find demand growth. And the next paragraph says EPA concedes no records will be kept. With regard to, next paragraph, this deficiency, says no records will be kept, and that could be solved by one of two ways. In the next paragraph, final paragraph, gives the two ways that the problem, according to you, could be fixed. Now, the first option you give, EPA didn't choose, but the second option you give says EPA could fix this problem, the problem that I've been talking about this whole time and that is mentioned in all of your comments, if EPA subjected facilities that choose to exclude demand growth emissions to record-keeping, monitoring, and reporting requirements to ensure that, and now I'm on JA55, to ensure that permitting agencies and enforcement authorities have sufficient information to hold facilities accountable. Now, EPA did not do exactly that. But what EPA did do is it said that if you're a source and you want to qualify for reasonable possibility, then you still have to keep records. You still have to at least keep your pre-modification records. If you're over the 50% threshold, not just when you exclude demand growth, but even when you include demand growth. So a company, say they're at 40% without including the demand growth emissions, but once they include the demand growth emissions, they're at 60% of the significant emissions threshold. In that case, they still have to keep the pre-modification records. So I guess it seems like you got almost everything you wanted. Why are the things that you didn't get, why are they as important as you're making out? And along those lines, there were a lot of states in the original round of litigation. There were a lot of states on your comments. You're the only state left. Is it that the other states were satisfied that EPA did almost everything you wanted EPA to do?
So let me address your first question first. We didn't get the most critical thing that we did want, which was reporting of pre-project emission calculations. And the reason why that's so critical is that information just is not available from any other source. And it brings transparency as well as accountability to the process. The problem that we found throughout NSR litigation, and I personally, on behalf of New Jersey, have been involved in 5 or 6 of these NSR enforcement cases. The problem is that permitting authorities don't know that a modification has occurred that might have NSR implications, and they have no way to check that. And in the litigation, when you finally get to that point, which is a very long, drawn out process and entails, requires a lot of resources, you find that the emission calculations that were done were very sketchy, if they were done at all. And so the importance of requiring reporting is that, the source knows that a permitting official is going to review the calculations. And so it really, I think, brings, as I said, some accountability to the process. And I think also in a lot of states, or at least in New Jersey, when you submit information to the permitting authorities, you have to do so under oath, or you have to certify that the information is true and correct to the best of your knowledge. So that's the key piece. That, we believe, is more important than anything, more important than post-construction records, post-construction monitoring, emission records, because all of that, we can come back and ask the source to provide the additional information. What we can't get up front are the pre-construction emission calculations, and we can't get those records pre-construction. Again, the whole point of the NSR program is to allow permitting authorities to evaluate before construction whether pollution controls are required, and they can't do that if they don't have the calculations in hand.
Ms. Morelli, I've taken up all of your time. I'm finished asking your questions. I thank you for your patience, and I especially thank my colleagues for their patience. And
Of course.
I promise not to ask anymore.
No, never a need for that promise. I want to make sure my colleagues, we'll give you time for rebuttal, Ms. Morelli, but I want to make sure my colleagues don't have further questions for you. If not, we'll hear from the government. Thank you, Ms. Morelli. Ms. Brown.
Good morning, may it please the court. Laura Brown on behalf of the Environmental Protection Agency. The challenged rule is the product of reasoned decision-making, and it should be upheld for 3 reasons. First, the Clean Air Act does not require sources to keep records, monitor emissions, and report to reviewing authorities when they determine that a modification does not require a new source review permit. But in recognizing the potential value of this information for enforcement, EPA balanced administrative concerns and set an objective, bright-line test that requires record keeping, reporting, and monitoring for those projects that EPA determines will have a higher probability of actually causing a significant
So
increase.
before we go too deep into the merits, can I just start you off where Judge Walker started off, which is with standing? And the government didn't make a standing objection here, and at least my experience with the government has been where the government believes there's any standing argument to be made, it usually makes it. And I'm just wondering, can we infer from that you think that there is standing here?
Well, Your Honor, I will note that we did in our brief assert a concern about standing with respect to any injury that is caused by sources within New Jersey, because New Jersey has. Well,
I didn't read you to be that's only sources within New Jersey, so it doesn't deal with upwind sources. But I didn't even read that to be a standing objection. I thought you made that was in the context of your merits argument, but maybe I missed something. Maybe you.
No, you didn't miss it.
Okay.
You're right. I just thought I would at least point that out, that we do think there is concern with their injury within the state of New Jersey.
Do you think New Jersey has standing?
Obviously, it's petitioner's burden to establish that they have standing, and I'm certainly not going to argue with your hypothetical, Judge Walker, that you laid out certain very detailed causes of events that would have to occur. I think Ms. Broom will probably address standing in a much more educated fashion, since it was actually raised in her brief. We did determine, our initial assessment was that New Jersey did have standing with respect to out-of-state sources. Okay. Second, for those modifications that do not trigger the record-keeping, monitoring, reporting requirements, EPA explained how other records routinely kept by sources will aid it and other reviewing authorities in enforcing new source review. And given EPA's vast experience and expertise in enforcing new source review using these type of records, its explanation should be given deference.
Let's assume that, as you argue, that the court must defer. This is an area of EPA expertise. What is the expertise that responds to petitioner's argument that as to pre-construction, there are no substitute records? And if those records are not available pre-construction, you heard all the things she said. Why is that a matter to which the court should defer because of the agency's expertise?
Well, I would note in the first instance that we do not concede that this information.
Would you agree that whether there are pre-construction records required or not is just a fact question?
So what EPA has determined, given its expertise and experience in administering the new source review program, is that actually minor new source review permits, which must be applied for prior to construction, could provide states such as New Jersey with the information that it seeks about a proposed modification that does not meet the major new source review record keeping requirements.
Minor sources. What about major sources?
Well, so the minor new source review program applies to major sources when they make determinations that a modification is not a major modification under the Clean Air Act, under the new source review program. So major sources can submit minor source new source review applications for those modifications that do not meet the major trigger.
Language, counsel, but I'm thinking somebody's going to spend $500 million building a new plant. How are minor source records going to provide the information?
Well, in that instance, if the source determines that there is not a major modification, it sounds like you're hypothetical. If someone is going to build a new plant, then that would automatically fall within the major new source review program, and would also be require a new source review permit as a new source. This
so
rule,
telling me that counsel is just wrong?
I think counsel has overstated her concern, or New Jersey, excuse me, has overstated their concern about the lack of available records pre-construction. Actually, New Jersey's brief on this point, New Jersey's reply brief strengthens EPA's point. For instance, New Jersey has adopted regulations that require sources, major sources, that have determined that a modification does not trigger major new source review, to submit to the reviewing authorities either a notice or a permit application describing the proposed modification and any change in emission as a result. So even in New Jersey, when a major source makes a determination that a change or physical project is not a modification that falls within the major new source review program, New Jersey is still getting the information it needs to make a determination of whether there could be a major new source review implication.
Does that apply to upwind sources?
State. We're all going to ask you the same question. What about out-of-state sources?
So so out-of-state sources are under the new source review regulations required to provide notice to states within the air quality region of minor new source review applications, and provide the states an opportunity, and the public too, to comment on those minor new source review applications, which are pre-construction. And so New Jersey will have notice of minor new source review permit applications for from sources within, for instance, the state of Pennsylvania or other states within the regional air quality district.
Is there no gap? Is there no delta there in between where there's a modification that doesn't arise to the level that requires reporting, but that also wouldn't come under minor source, so that New Jersey's actually not going to know about the modification?
I don't think I can say there's no gap. So states have the authority to determine if there are categorized insignificant activities that it determines are exempt from the minor new source review program. And so those are specific activities that states have made a specific determination or types of projects that really could have no, or are exempt, would have no influence or impact on the state's air quality and do not require an actual pre-construction permit. That is allowed under the statute, but it's going to be, in my understanding, is it's pretty rare. So either a source is going to seek a major new source review permit, and if it doesn't, then it sort of falls into the minor new source review bucket, and there will be notification to the reviewing authorities about the type of project that source is proposing.
And I'm just talking about out-of-state, upwind sources, right? I'm not talking about within New Jersey sources.
Sure.
And you're talking about the same thing you're talking about?
No, I am talking about out-of-state. So there might be a gap. There could be a gap of insignificant projects that a state, and for instance, Pennsylvania determines is exempt from minor new source review. And so that's small.
But that's even south of minor. It's insignificant. Right. So that's even, according to whatever jurisdictions are reviewing it, even more trivial than minor.
Correct. That's correct.
You're saying there's no gap between minor and major, such that
I am not aware of any, and based on my discussions with my client, that it is either the permit application will be either it'll be either a major modification or a minor modification, or an insignificant activity.
So I'm not sure that that's consistent with your brief, but maybe I just am misunderstanding. The smallest would be completely insignificant. They would have to get a minor permit. No.
No. So there's major new source review, which is for major modifications. And then if a modification is not a major modification, then most likely it is a minor modification. However, there are some projects that a state can exempt from the minor new source review program that are so insignificant.
So there's completely insignificant, and then there's the minor modifications. And when that happens, there's some reporting that goes on to the state through the SIPs. Is that
correct?
Right. Okay. And then there's also a modification that has a reasonable possibility of being major. That's next. And then there's a modification that is major.
Right.
Now, I'm wondering, because I'm still not sure, is there a gap ever between a minor modification that triggers SIP reporting and a reasonable possibility of a major modification?
Yes. So, and I think
how rare is that?
So if I'm understanding your question correctly, a major modification that, a determination that a modification is not a major modification, but has a higher probability of potentially being a major modification, that falls within the reasonable possibility standard.
But what if it's below the reasonable possibility standard, but above the minor modification SIP standard?
So if it's below the reasonable possibility standard, then in most cases, it needs a minor new source review permit.
So I get that, and I'm just trying to figure out what does most cases mean.
What's the most? Why do you say why do you say most?
99% of cases, 60% of cases?
Well, because of this, the category that could be exempt.
Insignificant.
Insignificant, correct. So it either is a major new source review project, or a minor new source review project that may or may not be subject to reasonable possibility record keeping. And then there's the third category, this insignificant. So the reasonable possibility standard, it covers the minor new source review program, but only those that are more likely or potentially likely to trigger a major new source review.
And the insignificant is the smallest of those.
That is the smallest, which states have just exempted as a.
I'm sorry, Chief Judge.
No, not at all. Not at all. I think we're asking the same questions and going to the same place. Can I just ask, but I don't want to cut you off, Judge Walker, if you have can I just ask the question in this following way, just to make sure I understand the typology? So let's just assume away the insignificant ones. So you don't need to caveat your answer, at least for these purposes, with respect to the insignificant ones. Put those to one side. Then if, as I understand New Jersey's argument, they're saying that for some, if it's not major, so that we're in reasonable possibility land, there's going to be some projects as to which they receive no notice that it's even happening, because the reporting part of it is not there. Record keeping might be there, but reporting is not there. And as I understand your response, you're saying, no, that category doesn't really exist. Again, putting aside insignificant, because there will be awareness of it by virtue of minor.
So that is generally, yes, I think that is generally correct. I am afraid to say 100% that there could not be one specific type of project that I'm just not thinking of sitting right here, but generally, yes, that a state will receive notification of a project that does not a major modification through its minor new source review program. Now, New Jersey.
Let me say, if one of us wants to say that in an opinion, where in the JA should we look to find support for that? And you don't have to know the number off the top of your head, but if you could give us a hint.
Yeah, so if you, I think it's actually within the regulation, so 40 CFR 51-160B, that describes what EPA requires of minor new source review programs, as well as within EPA's, the Federal Register associated with the promulgation of this rule. EPA discussed the sufficiency of minor new source review programs as supporting a gap filler. I just would like to clarify, though, that New Jersey might not itself receive notification for every minor new source review permit occurring outside of its jurisdiction. For those jurisdictions that are not within the air quality region, sources are not required, the states are not required to provide notice to other states about sources that are making a minor source modification.
What if it's a downwind state, though? I can understand if it's a state that's not even within the the wind column at all, but if it's a downwind state within the way we usually think about downwind states under Homer and all the statutes and regulations that apply to that dynamic, would New Jersey get notice as a downwind state or no?
So under the regulation, New Jersey is only required to get notice from those states that are within its air quality region. From a practical perspective, I do not know if there are downwind states that are not included within that district, but if it were outside of it, or outside of that region, but if it were outside of the region, then it would probably not receive notice.
Probably not, okay.
I see my time is up. I could just make one final point. What New Jersey seems to seek here is reporting for all modifications, or virtually all modifications, no matter how insignificant. And that reporting could actually also impose not only a burden on the regulated community, but also a burden on reviewing authorities, especially those with small staff or that lack resources, to review all proposed modifications and ultimately distract them from those modifications that have a higher probability of potentially causing a significant emission increase. And what EPA was doing as part of this rule is assisting reviewing authorities and focusing their attention on those types of projects.
Can I ask one more question? Between 2009 and 2019, EPA was, I guess, reconsidering the 2007 rule, and then after 10 years of reconsidering it, it decided not to reconsider it. What was that all about?
I think that there was perhaps a change in priorities. I don't know that I can speak directly to the decision making that was made on why not to reconsider. That wasn't actually part of this challenge.
Okay.
Thank you, Ms. Brown. Unless my colleagues have further questions, we'll hear from intervener counsel. Ms. Broom.
Okay, thank you. I think I'm just unmuted now. May it please the court, I had a presentation, but I guess what I'd like to start with is the fact that in the New York case that gave birth to this rulemaking, the court stated less burdensome requirements may well be appropriate for changes or sources with little likelihood of triggering NSR. And as Judge Williams said in his concurring opinion, EPA need not show that the system chosen will achieve perfect NSR compliance. Perfection is often too costly to be sensible. And I lay that out as a predicate, and I would like to explain. I do a lot of compliance work with big facilities and small facilities. So the way that the program works, and Judge Rogers, to your question earlier, you have major new source review and minor new source review aren't addressed to major and minor sources. They're addressed to projects. And so you get this misnomer because it's called new source review, when it's really maybe should be better called new project review. And this rule is solely concerning existing sources and modifications at existing sources. And so if you have a refinery or an automobile manufacturing plant, there are some projects that will trigger major new source review because they exceed the significance levels. And those go to major NSR, but most projects at a facility trigger minor new source review and get these minor source permits, and that's what the states deal with. And so someone asked earlier if there is a gap there between major and minor. No, there's no gap. Minor goes up to the major source trigger level, and then below minor, there's this de minimis insignificant stuff. And so an example of that is there are a list of exemptions in New Jersey's rules. New Jersey Administrative Code 72726.4 contains a list of exemptions for things like adhesives and sealants that contain less than 20 grams per liter of volatile organic compounds. Very specific things that the state has determined and EPA has approved after a public notice and comment process that those things are insignificant. So I would go back to the state implementation plan, even though one individual exemption and the use of that might not be reviewed, that the fact that there would be an exemption at that level, and there aren't a lot of them.
Ms. Broom, the
Yes.
state implementation plans for minor modifications, do they all require reporting of pre-modification record keeping?
No, and they never have.
That's the whole problem, according to New Jersey.
So that takes me back to my point on perfection. I mean, the fundamental question is, and EPA made this point in their brief, that if you require reporting of absolutely everything, you're going to lose the wheat for the chaff, and you're going to miss the projects that you really should be paying attention to. And that if you have to report, things happen at a major plant every day. They're doing maintenance. I'm sorry. I'm not talking about the insignificant modifications, the routine maintenance, those kind, but the modifications that are greater than insignificant, but that are minor new source review. Right.
In those instances,
you have to get a permit.
It is the case that, so you do or don't have to report your pre-modification record keeping.
You would end up on the application form, and this is not in the record, but this is just from my experience. So on the application form that you fill out for a minor NSR permit, you have to tell them what your emissions are and what you're doing.
So then there is reporting of pre-modification records.
Right. It's just not pursuant to this rule.
So can I ask a follow-up question about that? So if the application has that information, the application is submitted to whom?
The New Jersey DEP or the New York Department of Environmental Conservation.
If it's an in-state source, right?
Yes.
So then if it's an out-of-state source, if you're downwind from an out-of-state source, how does the downwind jurisdiction?
So there's a public notice and comment process under minor NSR. So they would have to look at the New York DEC's public notices, which are on its website, or, everything's changed between print, paper, newspaper, but there is a public notice process. It's on the DEC's website. Pennsylvania, the same thing. And I will say that the states that blow towards New Jersey have some of the most extensive minor NSR programs in the country. And I know they cited, something in Kansas, but Kansas doesn't blow to them. And I could quibble with how they describe that, but the states that they're dealing with, to the extent you ask the standing question, It's just makes their claim entirely speculative.
Yep. Well, even if Kansas is not a significant source, Kansas is a significant state. I'll just say that as somebody from Kansas, but
it's not always.
I've been to Wichita.
If my colleagues don't have any further questions for you, we will hear from Ms. Morelli on her rebuttal. Thank you, Ms. Broom.
Thank you.
Ms. Morelli, we'll give you 3 minutes of your rebuttal, but Judge Walker.
Could you start with the argument that both of your opposing counsels made that you will be easily distracted by too much information?
Not at all, because, the permitting authorities, they know what they're doing. They process lots of applications. They can look at an application and the emission calculations that are done and evaluate for themselves, do we think this is going to be problematic or not? And that's their job. But they need that information to be able to do that analysis. But in terms of overburdening them, no, they would like to have the information so they can at least have some sort of check. And, and it may be that post-project emissions raise a concern, and then they can go back and look at what was submitted beforehand and determine, wow, was this really off base or what's going on here? But a couple things I wanted to address really quickly on the burden. Perfection may not be required, but the ability to enforce certainly is required. And as far as the burden, EPA itself, when they promulgated the final rule, acknowledged that requiring sources to keep records, the emission calculation records, they're already required to perform. And I want to make that point because that's important. They're already required to do the calculation. So EPA itself said requiring them to keep those records is a minimal additional burden. Our position is likewise, requiring sources to report those emission calculations is a nominal burden. They have to email it to the permitting authorities. So not a great burden. The second thing I wanted to address was this issue of minor news source review, which I think is really a red herring. So minor news source review, major NSR applies to major sources, which there's a defined list for sources who emit or have the potential to emit 100 tons or more of NSR pollutant. Or there's a catch-all category for sources that emit or have the potential to emit 250 tons per year of a pollutant, a regulated pollutant. So if those major sources do not think that a project they are proposing, which will increase emissions, but they don't believe it will increase emissions enough to trigger NSR, then yes, they apply for a minor NSR permit or permit modification. But unless they are projecting that the project will lead to increased emissions that could result in exceedance of a NAAQS, a National Ambient Air Quality Standard, or that will result in a significant emissions increase. For most of these programs, it's not a case-by-case review. It's done on a programmatic basis. You have permits by rules. You have general permits. I mean, the authorities don't have time to review each and every minor new source permit application in depth. They are not required to submit the pre-project emission calculations that they are under major NSR. And sources or states, that only adopt the federal rules are clearly not required to submit the pre-emission calculations.
Ms. Morelli, I'm confused between two things you just said. Maybe you meant them both, but one thing you seem to say is for a minor modification, the state authorities that would grant a permit for that minor modification don't have time to thoroughly review the reporting that is done by the facility. And then I also heard you just say the reporting that's done by the facility is not really much reporting at all. Did you mean just the first thing, or did you mean both of them?
Sorry, I didn't mean to say it's not that they don't have the time. It's that there's a lot of minor applications as opposed to major applications. But the thing is, and that's one of the reasons why for minor applications, they require less information, generally speaking. They don't require the in-depth information that you would submit with a major modification application. So it's a much less rigorous process. Less information is provided. It's not that the permitting authorities don't review the information that is provided.
No, I guess that if a unit makes a minor modification, does the unit report does the facility report the pre-modification emissions?
I believe they do. Yes.
Okay, so that seems to me like the ball game, but.
Well, I would disagree, because what they're required to do is not just report what they're emitting now. They have to, under major NSR, report what they project future emissions will be, which can entail, they can consider a lot of factors.
But Ms. Morelli, you were telling us earlier that the thing that you really need is you need reporting of pre-modification emissions. The post-modification stuff, you can get that when you need it.
If I stated that, sorry, I didn't. Let me clarify. What we need are the pre-project emission calculations that project future emissions following the project. Those are the critical things, the critical information that we need, permitting authorities need to evaluate NSR compliance.
Thank you. Unless my colleagues have further questions. Thank you, counsel. Thank you to all counsel for your arguments this morning. We'll take this case under submission.
Thank you.
This honorable court is now adjourned until Tuesday, November 3rd at 9:30 a.m.